Like so many other concepts in constitutional law, the right to privacy is linked to vying interpretations of what the Constitution means. That we now recognize and protect not only traditional privacy rights against the state, like expectations of privacy grounded in property rights, but also privacy rights in marriage and personal relationships, a right to privacy that protects a woman's right to choose whether to terminate her pregnancy, privacy rights in same-sex relationships, and even a limited privacy right in end-of-life decisions, shows just how successful a more contemporary interpretation of the Constitution has been over the last 40 years. But the criticisms of this capacious understanding of privacy rights also shows the viability of a more traditional and originalist approach to constitutional interpretation. Before we jump into these controversial right to privacy cases for this section, though, we have to appreciate the fact that the concept of a right to privacy has a long tradition in the common law and American constitutional law. At least since the 19th century, the court has recognized a limited privacy right, starting with the increased protection that the court placed on property rights. And especially as the court began to develop its Fourth Amendment jurisprudence during the 1920s and Prohibition, Americans were very comfortable with the general notion of a right to privacy. Moreover, as the court began to recognize and enforce more aspects of civil rights and civil liberties after the constitutional crises of 1937, it was only a matter of time that other rights, like those that would eventually be protected under the umbrella of privacy, would come before the court. But changes in the larger social and political climate of the United States during the 1960s and 1970s best explain the immediate acceptance by the court of the extension of privacy rights. The sexual revolution of the 1960s and 70s sensitized American culture, politics, and eventually the law, and pushed the court to formally recognize that sexual intimacy and its attendant concerns, especially the choice of whether or not to start a family or even have children at all, even outside of marriage. We see both the older conceptions of privacy and the more immediate concerns that would widen the right in our first case, Griswold versus Connecticut in 1965. In Griswold, the majority overturned a Connecticut law that not only prohibited the use of birth control itself, but also prohibited the dissemination of information about contraceptives more generally. The law, the court's majority argued, infringed a right to privacy concerning the most intimate decisions of married couples, thus violating the 14th Amendment's Due Process Clause. The court found this right in two places in the Constitution, even though the right is not explicitly written down in the text itself. One place was in the, quote, penumbras and emanations of the Bill of Rights. The First Amendment's free speech and association protections, plus the Third Amendment's prohibition against the quartering of troops and homes, plus the Fourth Amendment's warrant requirements, suggested a larger privacy right that the founders sought to protect in the Bill of Rights. You would have to have a right to privacy in mind, they would argue, if you explicitly sought to protect speech, association, our homes, and our person and property from unreasonable searches and seizures. The court also suggested that the right to privacy could be found in the Ninth Amendment, which provides that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the court recognized both an older basis of privacy and a newer, more contemporary one. Of course, the court's decision was not unanimous, and the dissents, especially from Justice Black, have characterized larger criticisms of the court's privacy jurisprudence ever since. Justice Black argued that reading into the Constitution rights that were not explicitly enumerated created two dangerous problems. The first was that if the court could simply insert a right into the text, it could just as easily take that right away. The second problem was that in reading these rights into the Constitution, the court was substituting its understanding and interpretation of the document with that of Democratic majorities. In the case of Griswold, then, the text of the Constitution is silent regarding a privacy right concerning contraception. Who then is more legitimate in deciding whether this right exists, the unelected court or the Democratic majority of Connecticut that enacted the law? This question still serves as a basis for contending notions of property rights. The subsequent development of privacy rights, though, would not only widen but become more controversial. Soon after Griswold in 1965, for example, the court extended the privacy right with respect to contraceptives to unmarried as well as married couples. But the most controversial development in privacy rights is, of course, its extension to abortion rights in Roe v. Wade, as the court extended the privacy right to a woman's decision whether or not to terminate her pregnancy. Importantly, the court did not recognize an unlimited right, as it initially allowed the abortion right to be more regulated by states as a pregnancy progressed through its 3 recognized trimesters. And even when the court became more solidly conservative throughout the 1980s and into the early 1990s, the court still upheld the right, even though it jettisoned the trimester framework. In its place, it created another standard to protect the right and the right of states to regulate it. The test now is whether a regulation creates an undue burden on a woman's right to terminate her pregnancy. As controversial as privacy rights have become in the area of abortion, the court has also found that intimate relations between same-sex couples, as well as end-of-life decisions, are also protected as privacy rights. So as you wade through these controversial cases, think about the following questions. If a right to privacy exists, where exactly in the Constitution is it found? In the, quote, penumbras and emanations of the Bill of Rights? In the 9th Amendment? Maybe somewhere else? Does it even matter that the right is not enumerated? Are these areas, a woman's right to choose, intimate sexual decisions between adults, and even end-of-life decisions, too fundamental to go unprotected? Should these areas of privacy rights get the same protection as enumerated rights, like those in the Bill of Rights? And finally, who is more legitimate in determining what these rights are? Unelected judges or Democratic majorities? These are controversial cases that often provoke extreme reactions, but they are also some of the most important and interesting cases in American constitutional law. Use that emotion to help you think seriously and critically about them.